Hello, I'm Joshua Kaufman, an attorney. In this segment, we're going to talk about fair use, which is probably the most complex and controversial issue in copyright law today. Well, I need to go back a little bit to understand the concept. Basically, when we grant someone a copyright, we're granting a monopoly. We're saying basically, you, creative party, you author, writer, musician, songwriter, filmmaker, whoever, you have a monopoly in your work. You get to decide who gets to reproduce it, how it's exploited, how it's made into derivative works. So we're granting a strong monopoly here. Well, under U.S. law, we have a strong presumption against monopolies, antitrust laws and all that. So we need to have the copyrights and the monopoly in order for the creative parties to be able to exploit their works, earn a living, and create. On the other hand, sometimes there's public policies where society has a need to be able to have those works reproduced without having to ask permission of the copyright owner. So the courts established a doctrine called fair use. Later on in the 1978 Act, it was codified and was made part of the copyright law, Section 107. And that says, basically, notwithstanding all the rights that you have under Sections 106 and 106A, which are the basic sections that spell out the rights, there are certain times when people can make works, copies of your works, derivatives without permission. The Copyright Act says for such things, it lists them, some as givens: criticism, comment, news reporting, certain kinds of limited teaching examples, scholarship, and research. So let's look at what we're talking about there. We're talking about news reporting. I'm covering a opening of an art show. And to do that, I'm taking a picture of the painting in the gallery, so I can write my review and show to my readers what I'm talking about. That would be a fair use. That would probably also come under comment and criticism in addition to news reporting. News reporting might be I'm standing on the corner of a street corner reporting on a crime, and behind me there's a billboard or a mural, and that gets captured in the news story. That's going to be a fair use. Teaching, it's limited. There have been a lot of cases where teachers and educational institutions have overstepped. But if I'm at the last minute, there's an article and I want to make a few copies and hand them out to my students, I'm going to be allowed to do that. On the other hand, I can't systematically just reproduce things instead of buying textbooks, make course packs and things like that. And also in news reporting doesn't mean I have carte blanche to take other people's copyrighted materials and reproduce them in my news. There are times you can and the times you can't. Fair use is the most complicated area of copyright law, trying to determine what is and what is not a fair use. So in the Act, they give us a four-part test, which is supposedly not all the elements, but I can't remember a court actually going beyond an analysis of the four parts of this test. The first part is the purpose and character of the use, including whether such use is of commercial nature or for nonprofit educational purposes. If a work is being done by a nonprofit, that does not, let me repeat that, just because you're a nonprofit does not mean you can violate people's copyrights. That's not what is intended, and that's not what the courts are saying. But they look at the nature of the underlying use. Is it commercial, or is it for some nonprofit public good? And that's part of the evaluation. You weigh it. Now, simply because a work is being done for commercial purposes does not in and of itself mean that it's not a fair use. Since most of the examples I gave and most examples you'll find, there is a commercial element. I sell newspapers. I get paid for my reviews. I get paid to teach. So it's being simply commercial goes against fair use, but is not determinative. Today the key is it transformative? Is the nature of the underlying use transformative? Is it adding something new to it? Is it, and this whole issue of what is transformative, there are dozens of cases now before all the courts, the Supreme Court, the courts of appeal, And there is no simple current answer of what is transformative. So you have to look at the cases, and you really want to have, if you're going to talk about fair use, if you're going to say, well, I'm not going to get permission, I think it's a fair use, you really need to go to an attorney, and not just any attorney, but one who's very well versed in copyright law. But you look to see whether the nature of what you're doing is what is considered transformative. If it is, then that first factor, and therefore would weigh in favor of fair use. But again, that's not necessarily determinative. It's strong, but it's not determinative. The second part is the nature of the copyrighted work. First, is it published versus unpublished? Unpublished works have much more protection than a published work, so a published work would be more likely to have a fair use than an unpublished work. But you also look, when we're talking about the nature of it, is it creative work? The more creative it is, the more protection. So simple news stories or things that are mostly facts will probably have less copyright protection. Not that they don't have copyright protection. Trust me, news stories have copyright protection, but it's less so than something like a book or a painting that is purely creative work. The third factor the courts will look at is the amount, the substantiality of the portions used in relation to the copyrighted work as a whole. And we look at two things. We look at the quantitative as well as the qualitative elements. So when we're looking at the quantitative elements, it's how much. What percent of that work is being taken? Is it half of it? Is it 20%? Is it 3%? You look at it in terms of words of a book. You can look at seconds of a movie or a music. So you look at how much is being taken. But you don't stop there. You can't just say, oh, I didn't take that much. In fact, you have to look at how important it is to the underlying work. Is it the heart of it? So if you just take a little part of a song, but it's the hook of the song, it doesn't matter, it's a small percentage, that's going to be considered a substantial amount. The leading case here had to do with Gerald Ford's memoirs, where a magazine published only one small part of, it was like 300 words out of an 80,000 word book, but it was why Richard Nixon was pardoned, why Gerald Ford pardoned him. Well, that's the most important part of the book. And the Supreme Court said, no, that goes against fair use because you took the heart of that book. So we look at it quantitatively and qualitatively. And the fourth factor is the effect of the use upon the potential market for or the value of the copyrighted work. So in other words, is your use, and also you have to extrapolate, if everybody did what you did, would that undermine the market for the underlying work? And if the court finds that it does, in other words, if everybody did what you did and then no one would buy the underlying work, then in fact that's not going to be considered a fair use. Now, one of these things has to do, which is part of this, and the most classic fair use, though, I wanted to mention in this, is parody. Because no one's going to grant somebody permission to make fun of their work, so parodies are also considered fair use. And the First Amendment also plays a role in fair use determinations. So again, you have fair use, the most complex aspect of it. It is in motion. It is called upon commonly. Anytime anybody makes a copy and they don't have a license and they're looking for a defense, everybody says fair use. The courts are becoming more and more amenable to fair use arguments, but it is not for the faint of heart, and you really need an expert to consult with to ask, is my use going to be a fair use? So it's there, it's important, but it's a very, very tricky area. Thank you very much.